The Health Department has announced revised COVID-19 regulations, with most of them remaining the same. The department has also extended the period for public comment on these health regulations. Some health experts already advancing several comments relating to these amendments, and some people suggesting that these could limit constitutional rights, while others maintain that they cannot exist outside of the requirements of the Protection of Personal Information Act. Let's get more on this now, and we are joined by the adjunct professor at the Nelson Mandela University, that's Professor Sizwe Snail, and we're joined by legal expert, advocate Mkhululi Stubbs, who also joins us for this conversation. Gentlemen, thank you very much for your time. I don't want to poison your mind with what is already being said publicly. Let me start with you, Advocate Stubbs, and ask the question around the constitutional rights. Is there anything that stands out for you that could potentially trample the rights of citizens of South Africa?
Hi, Mkhululi. Thanks very much. In answer to your question, I would ask you how much time you have. The list of constitutional rights that could be implicated in regulations like these is long. But let me try to stick with the low-hanging fruit. I mean, the Constitution establishes a right to dignity, and dignity enshrines the right of everyone to autonomy in making their own decisions. Will regulations that force you to submit to a medical examination bear on those rights? Absolutely. Will they be unlawful? Perhaps not, but certainly bear on those rights. The right to privacy, Section 14, the right to freedom and security of the person. I believe that there are some religious rights that may even have been implicated, if I've been reading the media correctly. The right of assembly, the right of movement, the rights of children, if children are forced to submit to a medical examination, and the list goes on. I don't envy the task of the lawyers who are advising on how to get these regulations through without challenge.
Yeah. Professor Snail, let's come to you. At the level of personal information, you've already heard Advocate Stubbs talking about the right to privacy. Any risks on that side?
Yeah, I think the issue relating to collection of personal information, in particular, special personal information, in other words, information relating to your health, your COVID-19 status as well. Those are special personal informations that cannot just be processed without your explicit consent. Now, there are some instances where obviously the law comes in and says, look, we're having a state of disaster, or we're having a security issue, and under those circumstances, the POPIA does make certain exceptions. But to blanketly go and collect data and say that you're doing so for the purposes of contact tracing and so forth, we've already seen what happened at the beginning of the COVID-19 pandemic when they did attempt in laws or temporary laws at the time regarding contact tracing. It was a complete mess. And as a result, those particular regulations were removed. So, it seems as if we are at the end of the pandemic, but we are at the beginning legally.
Professor Snail, let me not move on from you just yet. Already there is sentiment being expressed that personal information, researchers should stay away or not try to monetize the information that has been collected from citizens to try and make money out of it. Is that just a simple warning, or have we already experienced examples of this?
Look, our POPIA is very clear. It says when you collect personal information for a particular purpose. So if the state says we need this data, we need it to analyze the state of affairs of COVID-19 infections in our country, and that is the purpose that you've collected it for. Should you want to further process it for another purpose, purpose that is not necessarily compatible with the initial purpose, you would have to go and ask for consent. We've known over the years the atrocities that has been happening with personal information of Africans being sent across borders and scientists abusing that personal information. So, you know, the POPIA is specifically there for that. In the instance where you want to do research or you know, historical analysis, there is the issue of anonymization that needs to take place. So you can't just do your research based on the information, who you know it belongs to. You know, you'll have to anonymize the data, make it non-identifiable, and then on that basis, you can use the excuse to say that you're doing it for research or statistical purposes. But even there, you know, it's a very thin line between the initial purpose and the secondary purpose that you're using the data for.
Yeah.
I hope that gives some clarity.
It does. It absolutely does. Advocate Stubbs, let's come back to you. The regulations, as one professor has already expressed, that this is simply, I'm really trying to not use the same level of strong language he used, but safe to say that this is actually quite stupid. It's cut and paste, as he sought to express. The people that, for example, are arriving in the country, they are still expected to produce some kind of certificate. If not, then they've got to produce an antigen test. If you go to a stadium and you have still got to make sure that you produce that certificate that says you are fully vaccinated, and the assumption is that if you don't have that, then you're not allowed to enter. There has been quite a debate around this matter. Do you want to weigh in on that, or do you have a specific question that you would rather have me ask? Because I do have.
Let me start by expressing my own view, seeing as I was given the opportunity. I think that before answering the question of is it permissible or appropriate for people to have to produce information in order to enter property, I might just take a step back and explain why it is that this area of lawmaking is so fraught and so dangerous for a lawmaker in a constitutional democracy. And the reason, in summary, is where we are as a species. We've come from a system of feudalism to democracy, from a system of authoritarianism and apartheid to a separation of powers where you have the executive, parliament, and the judiciary, a system of checks and balances. This is the executive doing what parliament is meant to be doing ordinarily. And that in itself, executive regulation making, it's sort of like Judge Dredd, if you'll permit the reference, of being, you know, the judge, jury, and executioner. Here, the minister is both the lawmaker and also the executor of the law. That being so, you're always going to have a tough time getting these kinds of regulations through. Now, coming to your question about the stadium, the first question that would arise is whether this is public or private property. But assuming that it is public property, the legal question differs. It stands on different ground when you as a person are making a choice and saying, I want to enter into this territory. This territory has rules that say if I don't comply with them, I won't be allowed in. If I choose to want to go in, then the law is going to regulate you differently than if you are simply on the street and someone says, grab that person and give him a medical examination. I don't suggest that the regulations go that far, but if it did say something like that, you'd have an entirely different situation. So I think that to the extent that the status quo has been maintained by the regulations, I want to be fair to the regulations and not say that they're stupid or whatever word was used. They might be permissible, but where they go further, the government is going to have to take a lot of time in order to show that it followed the right process, that it considered everyone's views, and that it came to a rational outcome in the end. So I think, in summary, I think that they have an uphill battle, but yeah, let's see what the future holds.
Final question, and very briefly, Professor Snail. A broad question, but I'm hoping you could summarize it. What is missing around these regulations?
I think that's a very broad question for a very short space of time. But I think what is important in these types of regulations is proper consultation with all the stakeholders, with all the people of South Africa, putting in the right checks and balances, as Advocate Stubbs already pointed out, so that it is a lawful process making. You know, I'm not one of those people who goes and bashes our government. Our government is also trying to make means. Our government is trying to curb the pandemic as well. So, you know, when regulations come out like this, it is upon us as citizens to comment, to say what it is that disturbs us about these regulations, so that when these regulations are fine-tuned, they are fine-tuned having regard to all people's rights, all people's interests in a fair and democratic society. I hope I didn't sidestep your question too much.
No, you didn't. No, you didn't. All right. Well, I suppose the Minister of Health will respond and say, well, this is precisely why I have extended the period for the public to comment, which is sometime in July, he said. All right, gentlemen, let me thank you to the both of you. That's Professor Sizwe Snail. He's with the Nelson Mandela University, and Advocate Mkhululi Stubbs, speaking on the constitutional side of things. Thanks indeed for your insights. All right.